Oh, yes, just as I previously noted in the video, I was talking about the royal courts and how the king deriving the power from religious law, that is divine law. Um, so, in other words, we have um, testament or religious law. We could be uh, Judaism, Islam, or Christianity. In this case, Christianity. This is where the kings derive their power. They said that they are the they are the God. This is the God's law, and the God has given them the authorities, this absolute power to interpret the law or to create the rules and change them however they see it fit. Um, um, but at the same time, with Magna Carta, that kind of changes. Magna Carta, uh, in, its intention was to kind of um, change some of the rights and give some of the rights to citizens and property rights and things like that that really helped kind of put this was this kind of initial phase of trying to curb some of that power away from kings. But in terms of English common law and how it it was derived and developed, is that as I said previously, it was a common courts, it was legal, um, local courts through the counties, through England. Uh, the local authorities would interpret the law and everything, but then the king kind of came in, and king would, in some instances, king was also traveling around England and with the justices and kind of interpreting the rules or giving the rules and all that. And we're talking about it is medieval times, so there's no per se legal training or anything like that. But at the same time, the king also realized that there should be also some kind of centralized power. So this is where we are talking about a centralization of courts. The royal courts moved to one area, and this is where people that with important complaints or complaints that royal courts should hear, they would hear and interpret. But of course, the, the king would have ultimate authority over it. You know, judges could interpret it and all that, but if the king says, well, that's not how it should be this way, then it's the king's word. But these, given the fact that these justices and the king would travel around the country, that was the same concept happened here in United States when Supreme Court was instituted. So we didn't have there was no Supreme Court building or in DC, so the justices would travel from state to state depending on the cases, and they would interpret the cases, but they were the ultimate bybider by the law, meaning they are the ultimate, they decide what the law will be and how the law is interpreted, not the president or the king or anything like that. And this is where we are talking about the division of power. But Magna Carta kind of puts things in the motion for giving little more rights to people and taking some power away from the king. Now, in terms of when I was talking about centralization, and I'm going to quote The Birth of English Common Law, this is the second edition by Vance Verkagen. We and I'm going to read one passage which is very interesting. It says the Henry II, who was the king around 12th, 11th century, and he says, was to rise to absolute predominance. Absolute predominance meaning there, the absolute power. There's no reversibility. There's no checks or balances or anything like that. King is the law. King is divine, and as that saying says, all hail to the king. It says the royal courts under Henry II as the freemen's courts of first instance for all more important and frequent complaints connected with landholding throughout the country. There was a dual phenomena here: centralization and specialization. Centralization meant that enormous amount of litigation would in earlier times have originated in local courts and stayed there, now came up before the central body of royal judges, which was I was talking about. These are the royal judges that they would interpret. He says, so the important cases, they would be transferred. So things that of minor complaints and all that, they would stay within the local courts, but then everything was transferred to that. Now, it's also, when we're talking about a specialization, this is where like local courts maybe did not have experience, or there were people who were not trained how to interpret property law or some kind of feudal or medieval time property law, and then it had to be brought up before high judges who had experience to interpret it, or the judge would have to interpret that, or the king would decide what the ultimate decision would be in that. So in the what ensues from there is that kind of a little more. There's now we are going to start to see some cases being built, which off of it will give the future judges how to interpret the law, how to see it, what would be the. But then again, there's no separation here between, and I'm talking about between church and state. Again, this is basically the origin of that law, the common law, as we said in previous lesson, was that it comes from Alfred the Great, and Alfred the Great interpreted religious law, and he used it to institute certain rules and regulations and order in England, while when the Vikings were, kind of stopped from coming to England from Norway, from Denmark. He instituted a religious law, and that law becomes kind of a ripple. It becomes a ripple effect for the future, how the future for next several hundred years would develop, and how the religious law would play a major part into the building a little more complicated law. As of course, as civilization progresses, you have a trade, you have contracts, you have property law, you have a criminal law, and these things were not really developed at that time. It was just general rules that you needed some kind of guidance to interpret that. It says, but what's it called, the bench law, or before the bench, these are the royal courts. It also that you would appear before the king himself. So if you had a really big important case, like today, if Supreme Court thinks that the pressing issue is of a great importance, and it's going to have a major impact on society, they're going to take it and interpret that law and try to lay out a land. And as we see some of the recent cases that the Supreme Court, but this was not a case. This is here where the justices would only would meet when the king decides. And if the king is not there, you really couldn't decide many cases. You couldn't, because the king had to make sure to oversee and all that, because of course the king wants to protect his own interests. The fascinating thing, as I was reading these books and some other books, the court, how it was developed, is that as the justices and of course the king, you learn a lot more, and this is where things start to build by case basis. But then, as a regular guys, and we know in common law, the judges, they look at the law, but they also look at the cases, how the cases were decided before that, and they go off of that. What is very fascinating about this, and talking about also Magna Carta, the one thing that Glanville, okay, so the book mentions also Glanville, and Glanville is early known like a lawyer, and he wrote early, like he kind of sat down and wrote what the rules will be and all that stuff. There's a long book about it. I think Glanville and Bracton. Glanville, he says, we do not know exactly when we're talking about exactly when did the courts of common pleas is the usual property, like a landowning, they would interpret that kind of law and all that. We do not know exactly when, but they were when Glanville wrote Magna Carta. At Westminster, the barons of Exchequer, where judicial business was sometimes done, also sat. Above them all, the king himself could intervene. When he was always absent, like Richard I, no regular court could develop before him. But when he was chiefly in the country, conditions were present for a branch curam rege. Curam rege means before the king, in a court of royal justices, traveling with the king, though not as a rule hearing cases in his presence. Those the 13th century common law courts had taken shape. The early years, so this is where you're talking about how all these different elements, when they travel, when they stay, when people are coming to plead before them, and how all these different changes that enabled for English common law to be kind of, to create a demarcating line between code law and English and common law, which is a case law too. So the fact that the judge would travel and the king would travel through different counties to hear the cases, or the cases that were different, that was an interesting. We don't see today president hearing the cases or anything like that, or Supreme Court justices coming to some local town to hear a case. No, usually you have to go to DC and file and follow all the procedure and rules and all that, and wait for quite a while if they're going to hear the case, if they're not going to hear the case, and things like that. The fascinating thing about this is that we have these different elements that come together, and so instead of using code law, let's just say you should not drive if the speed limit is, well, not in medieval time, but today, we're talking about today, kind of to put into context. So if the speed limit is 25, you drive 25, and this is the speed limit that you can go by. The judges would interpret that, and you would use yes, you would know that speed limit is 25, but you would also use what other cases were decided based on similar circumstances and all that. And this is called a major thing that gets developed later on into English system, and then eventually founding fathers, and it eventually finds its place in United States Constitution and the separation of powers, the checks and balances. And Magna Carta was that kind of an initial, another idea of Magna Carta is that was another initial step to put some kind of checks on the king, rather than just king interpreting the rules and arbitrarily and deciding who, what, and where, without really having, you cannot question it, you cannot turn it or anything like that. It was an absolute power. And this is where the checks and balances come into play, and this in terms of checking who, how can different branches of government check each other and keep each other in, keep one another into some kind of balance where not one is above the other and all that. And that gets developed mostly in the United States when, of course, Hamilton, who's a Federalist, also advocates to strong federal government, while Jefferson's advocates states should have precedence, and this becomes a whole different issue. But as we can see here, how the courts in medieval times and how the justices and the king himself interpreted the law, and also created the law. And then also the question is, as I might leave you with, is if the judges can make the law. There's some people argue that's not true. The judges do not make the law; they just interpret it. Well, there's a lot of wiggle room there too. A lot of debates that can go back and forth about that. But one thing I want to leave you off then is what is the rule of the law? If sometimes it cannot be questioned. especially at that time. And I'm sure maybe some instances today. Well, thank you. I will continue to fill in some more on English common law. Thank you.